What I'm going to show you today is the legal test North Carolina uses to determine who is actually an employee, the industries where this happens the most, and exactly what to do if you have already been hurt and are being told your label means you have no coverage. Why employers do this and why it is not a mistake. Let me start with the motivation because understanding why this happens is critical to understanding what to do about it. In North Carolina, most employers with three or more employees are required by law to carry workers' comp insurance that covers their workers in the event of a job injury. That insurance costs money. The premium is calculated based on the total payroll of the business and the risk classification of the type of work being performed. For a construction company with workers doing concrete, roofing, or electrical work, that premium can represent a significant line item in the operating budget of that business. But if the same employer labels those workers as independent contractors, the payroll shrinks for insurance purposes. The workers' comp premium drops or even sometimes completely disappears. The employer avoids paying their share of Social Security and Medicare taxes. They shed their unemployment insurance obligations. They reduce their legal exposure across multiple categories simultaneously. A win-win for the employer. I have handled workers' comp cases in North Carolina for decades, and I have sat across the table from insurance representatives and employer attorneys who were defending exactly this arrangement. What I can tell you is this. In industries where misclassification is most common, this is not a paperwork error. It is a financial calculation by the employer. The employer has done the math and decided that the cost of occasionally getting caught is lower than the cost of properly classifying and covering their workforce. That calculation works fine until one of those workers gets hurt. The NC legal test that determines your status. Here's the most important thing I can tell you about this situation. The label on your paperwork does not determine your legal status in North Carolina. Your actual working relationship is what determines that status. North Carolina uses what is called the right to control test to determine whether a worker is an employee or an independent contractor. The question is not what your contract says. The question is whether the company is exercising control over not just what work you do, but how, when, and where you do it. The North Carolina Industrial Commission and North Carolina courts look at a specific set of factors when trying to make this determination. Does the employer set your schedule, or do they tell you what hours to be on site? If they control your start time, your break schedule, the end of the shift, provide materials and tools, that is employer behavior, regardless of what a contract says. Does the employer provide your tools and equipment? If you show up and the company hands you a saw, a uniform, or a forklift, you are not working as an independent contractor in the sense the law intends. Can the employer remove you from the job without any contract-based process? An independent contractor has a service agreement with terms. If your employer can tell you to pack up and leave with no notice and no breach of contract consequence, that is employer behavior. Does the employer control the method of your work, not just the result? A true independent contractor is hired for an outcome. If someone is supervising how you lay pipe, pour concrete, or package product, that is an employment relationship. Are you working exclusively for this employer or do you have multiple clients? An independent contractor, in the true sense, maintains multiple business relationships. If you work for one company full time every week with no other clients, the contractor label does not reflect the economic reality. No single factor is automatic. The commission looks at the entire picture. But when a company controls your schedule, your methods, your tools, and your income, North Carolina courts and the North Carolina Industrial Commission have consistently found that the right to control test points toward employee status, regardless of what any contract may say. The industries where this happens the most in North Carolina. I want to be specific about where we see this classification most often in North Carolina, because if you are in one of these industries and watching this video, there is a real chance this situation applies to you. Construction is the highest risk sector. General contractors hire subcontractors, and subcontractors bring on workers and call them independent. By the time you trace the chain from the project owner down to the laborer doing the most physically dangerous work on the site, that worker may be 4 contracts removed from any entity willing to claim responsibility for their injuries. He has no workers' comp coverage, no unemployment protection, and no mechanism for getting medical care covered when something goes wrong. Warehousing and distribution is close behind. Staffing agencies bring in temporary workers for distribution centers and logistic facilities. The warehouse company tells the staffing agency the worker is their responsibility. The staffing agency has a contract saying the worker is an independent contractor. The worker gets hurt moving 300-pound pallets on a concrete floor, and everyone in the chain points to someone else. The gig economy in North Carolina follows the same pattern. Delivery drivers, independent truckers, app-based workers doing physical labor. When the injury happens, the platform company points to a contract saying they bear no liability because the worker is a contractor. In each of these industries, I have seen companies that are not confused about the law. They know exactly what they are doing. The 1099 is not an administrative oversight. It is a liability avoidance strategy deployed deliberately in sectors where the physical risk is the highest. If you are working somewhere as a contractor, but the company controls your schedule, provides your equipment, and you have no other clients, I want to hear about it in the comments. What industry are you in? What did your situation look like when you got hurt? Other workers in North Carolina reading this may be in the exact same position and will benefit from this information, knowing they are not alone when it matters the most. How to determine your own status right now. Ask yourself these questions honestly. Does your employer set your hours and your schedule? Do they provide the tools and equipment you use on the job? Do they supervise how you perform the work, not just what the finished results look like? Is this your only or primary source of income with no other clients? The more of those questions you answered yes to, the stronger the argument that North Carolina law should view you as an employee, regardless of what your contract or your 1099 says. Keep that assessment in mind and keep documentation. If you are injured on the job and your employer or their insurance company denies your workers' comp claim because you are a quote contractor, here's what you do in order. Step 1. File a Form 18 with the North Carolina Industrial Commission immediately. The Form 18 is your official notice of a workplace injury. Filing it preserves your legal rights and starts the clock on the employer's obligation to respond. Do not let anyone tell you that your contractor status means you have no right to file. File it regardless. The question of whether you are an employee or a contractor is one the commission will decide. Your job right now is to file the form. Step number 2, request a formal hearing by filing a Form 33 with the North Carolina Industrial Commission. When the insurance company issues a denial based on contractor classification, that denial triggers your right to have the classification dispute heard by a deputy commissioner. At that hearing, you present evidence about your actual working relationship. The employer insurance carrier present their contractor argument. The deputy commissioner decides. Step number 3, start documenting your working relationship right now before the hearing. Save every text message from your supervisor giving you instructions. Save emails about your schedule, your duties, or your work methods. Keep a record of what tools and equipment the company provided. Note who directed your work on a daily basis. This is the evidence that demonstrates the right to control test points towards employee status, and it is far easier to gather now than 6 months from now when everyone's memory has faded. Step number 4. Contact a workers' comp attorney in North Carolina who has handled misclassification disputes. This is not a routine workers' comp claim. It is a classification dispute that will be litigated before the North Carolina Industrial Commission. The employer will have legal representation at every step. You should too. Step number 6, the legal consequences for employers who misclassify. When a company is found to have failed to secure workers' comp coverage in North Carolina, civil penalties and criminal exposure can follow under GS 9794, which addresses the consequences for employers who willfully fail to carry the insurance their workers are entitled to. Misclassification of employees as independent contractors to avoid those coverage obligations also falls within the framework of Employee Fair Classification Act. But those consequences only happen when injured workers step forward and assert their rights. If you prevail on the classification dispute, the full range of North Carolina workers' comp benefits applies. Medical treatment, wage for replacement at 2/3 of your average weekly wage, and permanent disability compensation for lasting limitations. You may also face a battle over your MMI status and disability rating once the classification issue is resolved. There's a video on this channel specifically about what happens when a workers' comp injury is not healing and the insurance company is pushing toward MMI. That fight often comes next. What I want you to walk away knowing is that companies that deliberately misclassify workers in North Carolina are counting on one specific belief, that the 1099 means you have no rights. Because as long as you believe that, you never challenge it, you never file, and they never have to defend the practice or pay. You have rights. The North Carolina Workers' Comp system recognizes that labels on paper do not override the reality of a working relationship. The legal test is based on how the work actually functioned, who controlled it, and who provided the resources to do it. That test can and does result in workers being recognized as employees, even when every document in the file says contractor. If your claim has already been denied based on your classification, the next step is to understand your options and move quickly. I made a video specifically on what to do in North Carolina when a workers' comp claim is denied. Watch that video next. The process starts the same way regardless of the reason for the denial. $50 million has been recovered for workers in North Carolina. I've never once seen a worker who understood their rights and asserted them properly walk away with nothing. Know your rights. Watch this next. If your workers' comp claim has been denied because of a contractor label or any other reason, I made a video on exactly what to do when that denial comes in. That is your next step. King Law Firm is in the description. The consultation is free. The call is free. And if you've been labeled a contractor in a situation that does not feel right, drop a comment. Tell me what industry you were in. We can help.